Connecticut General Statutes Section 12 to 157. Method of selling real estate for taxes. Introduction. In Connecticut, when a taxpayer fails to pay property taxes, the municipality has the right to recover those taxes through a tax sale of the real estate. Section 12 to 157 of the Connecticut General Statutes provides the detailed legal framework for this process, outlining the necessary steps for notifying interested parties, conducting the sale, and managing any surplus funds that may result from the sale. Step-by-step breakdown. Initiating the sale, subsection A. The process begins when the tax collector levies a tax warrant on the delinquent property. The tax collector must prepare and issue formal notices to the property owner and all relevant parties with a legal interest in the property, such as mortgages and lien holders. These notices must include the taxpayer's name, a legal description of the property, including the address and any identifying boundaries or references to public records, the amount of taxes owed, plus interest and any associated fees, the date, time, and place of the tax sale. Notices are sent by certified mail and must be posted in a public location, filed in the town clerk's office, and published in a local newspaper at least 9 to 12 weeks before the sale. Multiple publications and postings ensure that all interested parties have sufficient time to be informed. Adjournments, subsection B. The tax collector may adjourn the sale for any reason, provided proper public notice is given at the time and place originally designated for the sale. If the adjournment exceeds 3 days, written notice of the new sale date must be mailed to the delinquent taxpayer and other interested parties. Conducting the sale, subsection C. The tax sale occurs as a public auction, where the property is sold to the highest bidder. The proceeds from the sale are used to cover the delinquent taxes, interest, fees, and other lawful charges. If there are no sufficient bids, the municipality itself may purchase the property. Costs and payment terms, subsection D. At the time of the auction, the tax collector is required to post the total amount of all taxes and fees owed on each property. Auction rules, including how payment must be made by successful bidders, are announced at the sale. The costs for hiring auctioneers and any assistance are added to the total taxes due from the delinquent taxpayer. Issuing a deed, subsection E. After the sale, the tax collector must execute a deed to the purchaser or to the municipality within 2 weeks. However, this deed is held unrecorded for 6 months. This waiting period allows time for the property owner or other interested parties to redeem the property. Redemption period and notice, subsection F. After the sale, the taxpayer and all interested parties are notified by certified mail and publication that they have 6 months to redeem the property by paying the full amount of taxes, interest, fees, and charges, plus 18% annual interest on the purchase price paid at the auction. For abandoned properties or special cases, municipalities may adopt ordinances that reduce the redemption period to 60 days. Insurance and receivership, subsection G. During the redemption period, the purchaser or the municipality has the right to insure any buildings or improvements on the property and can seek equitable relief from the court, including the appointment of a receiver, if the property is in danger of damage or poses a hazard. Municipal purchase rights, subsection H. If another municipality holds a lien on the property for unpaid taxes, that municipality may also purchase the property at the tax sale. Excess proceeds and escheatment, subsection I. Handling surplus proceeds. If the sale generates more money than needed to pay off the delinquent taxes, interest, and fees, the surplus is held in a separate escrow account by the municipality. If the property is redeemed within the redemption period, the surplus is returned to the purchaser. Unclaimed funds. If the property is not redeemed, the excess funds can be used to pay off other outstanding taxes owed by the same taxpayer. Any remaining surplus after covering all taxes, penalties, and costs is then transferred to the court. The tax collector must notify the taxpayer and all interested parties that the funds have been paid to the court. They have 90 days from this notification to file a claim for the excess proceeds. Escheatment. If no claim is filed within 90 days, the unclaimed funds escheat to the state, meaning they are transferred to the state's unclaimed property division. Individuals can still claim the funds by filing an application through the state's unclaimed property process, but the procedure becomes more complex once the funds escheat. Court process for claiming excess proceeds. Any party with a legal interest in the excess proceeds, including the taxpayer, mortgages, or lien holders, can file a claim with the Superior Court within 90 days. The court will determine the rightful distribution of the funds, considering the equities of all parties involved. Conclusion. Connecticut Section 12 to 157 provides a structured and detailed process for tax sales of real estate, ensuring that all parties are properly notified and given the opportunity to redeem their property. It also protects the taxpayer's right to any excess proceeds from the sale, though those funds must be claimed within the specified time frame to avoid escheatment to the state. This statute is foundational for property owners, lien holders, and municipalities, as it ensures transparency and fairness in the tax sale process while providing an opportunity for individuals to recover surplus funds before they are forfeited to the state.